Can a building code violation help prove my slip and fall case in New York City? Yes, a building code violation can be powerful evidence in a New York City slip and fall case because it can help show a property owner failed to meet required safety standards. A code violation by itself does not guarantee a successful claim, because you still must prove the violation caused or contributed to the fall and that you suffered damages. You also must file within New York's 3-year statute of limitations for this type of case. In a slip and fall case, you generally need to prove duty, breach, causation, and damages. A building code violation is especially useful for breach, because it points to a specific legal standard designed to keep people safe. New York distinguishes between violations of state statutes and violations of local ordinances. An unexcused violation of a state safety statute may be treated as negligence per se, while many municipal ordinance violations serve as evidence of negligence for a jury to consider rather than automatic negligence as a matter of law. For the violation to matter most, it should match the hazard that caused your fall, such as an open violation for a missing handrail when you fell on stairs without the required handrail. If the only violation involved something unrelated, like an expired boiler inspection, it may not help explain why you fell. Even when a violation is not the direct cause, a history of unresolved violations can support an argument that the owner ignored maintenance and safety obligations over time. A building code violation is an official notice that a property does not meet safety standards set and enforced by the New York City Department of Buildings. The Department of Buildings oversees construction and maintenance codes to help ensure buildings are safe for occupants and visitors. When a property fails to comply, the Department of Buildings can issue a violation and order the owner to correct the problem. New York City safety requirements can involve overlapping rules, including the NYC Construction Codes, the New York City Housing Maintenance Code, and the New York State Multiple Dwelling Law. These rules can cover structural integrity, fire safety, accessibility, lighting, and general maintenance obligations that can relate directly to fall hazards. Common hazards linked to violations include stairway defects, because stair geometry and handrails are regulated to reduce the risk of falls. Missing, loose, or improperly sized handrails can remove a critical safety feature people rely on for balance. Uneven step heights can be dangerous because they disrupt a person's natural walking rhythm and can trigger a misstep without warning. Worn, loose, or overly slick stair treads and landings can create a slip hazard and may support an argument that the property was not maintained in a reasonably safe condition. Poor lighting is another frequent contributor to falls, especially in public halls and stair areas in multiple dwellings. When hallways and stairwells are too dark, residents and visitors may not see uneven flooring, debris, or wet surfaces. If the hazard would have been visible with proper lighting, a lighting violation can be central to proving why the fall happened. Other violations that can lead to falls include broken or uneven flooring in lobbies, hallways, and common areas. Missing or damaged tiles can create tripping hazards that are easier to link to a breach of required upkeep. Defective elevators that stop unevenly with the floor can cause trips when people exit. Obstructed walkways or corridors can force people into unsafe paths. Water infiltration or plumbing leaks can create slippery surfaces that increase the risk of a fall. Sidewalk defects next to a building can also matter, and the rules described can make abutting property owners generally responsible for sidewalk maintenance and sidewalk injury liability, with an exception noted for certain owner-occupied 1, 2, or 3 family residential properties. To find out whether a building has relevant violations, a lawyer can check public records maintained by the city. The Department of Buildings maintains the Buildings Information System and also provides violation information through the DOB Now public portal, and some filings and compliance violations may appear in DOB Now. Safety rather than BIS. Housing Preservation and Development maintains a separate database tracking housing maintenance issues. These records can help show notice, because documented violations that remain uncorrected for weeks or months make it harder for an owner to claim they did not know about a dangerous condition. In addition to database searches, an attorney may request copies of specific violations, subpoena inspection records and maintenance logs in discovery, and retain building code professionals to inspect the property and identify violations that may not yet be documented. After a fall, your first priority should be medical attention, even if your injuries seem minor at first. If you are physically able, take photos of the condition and the surrounding area, including debris, wet surfaces, broken flooring, or missing handrails. Report the incident to the property owner, building manager, or store manager and request a written copy of any incident report. Write down what you remember, including the date, time, exact location, what you were doing, what caused you to fall, and the names of any witnesses. Keep your medical records, bills, and receipts related to the injury. Do not give a recorded statement to an insurance company before speaking with an attorney. Kucher Law Group handles slip and fall and premises liability cases throughout Kings County and New York City, and the law firm investigates DOB and HPD records and works to connect documented violations to the cause of the fall. This law firm can also file cases in Kings County Supreme Court at 360 Adams Street when necessary. If you are considering your next steps, Kucher Law Group can review how a building code violation fits into the duty, breach, causation, and damages you must prove, and a lawyer can use the public record trail to strengthen the claim. Call Kucher Law Group at 929-563-6780 to discuss your situation with an attorney. You can reach the law firm at 463 Pulaski Street, No. 1C, Brooklyn, New York, 11221, United States.